The final case on the docket this morning is from Wyandotte County. It's number 123-376, entitled Carolyn L. Miller versus KVC Behavioral Health Care. Who do we have here for the appellant?
May it please the court, Robert Bruce on behalf of the appellant Carolyn Miller.
And the appellee?
May it please the court, Vaughn Burkholder appearing on behalf of the defendant appellee, KVC.
Counsel, I'll repeat just a few preliminary remarks. We have read your briefs, I remind you. So we are familiar with the facts of your case and what the issues are. You might keep that in mind during the very limited amount of time that you have to make your argument. Each side is given 15 minutes for your argument this morning. And after the argument, we'll take your case under advisement and get a written decision out to you just as soon as we possibly can. Mr. Bruce, we will start with you as the appellant. Do you wish to reserve any time for rebuttal?
I do, Your Honor. May I please have 2 minutes for rebuttal?
That is granted, and you can begin whenever you're ready.
May it please the court. I'm Robert Bruce, and I represent the appellant in this matter, Carolyn Miller. At the heart of this appeal is the question of what degree of finality is required before collateral estoppel can be appropriately applied in a subsequent action. Here, a determination that by statute was not binding in the claim in which it was made, not subject to appeal, and had not conclusively determined on a full presentation of the evidence, the facts, is being used to deny Ms. Miller her day in court. This was done despite a direct request by appellant's counsel that the matter be reserved for redecision in this matter. Therefore, the district court erred in granting judgment on the pleadings, and we ask that that decision be reversed and remanded. Collateral estoppel under Kansas law requires three things. However, only the first element is truly at issue in this matter. As laid out by the Supreme Court, the first element requires a prior judgment on the merits, which determine the rights and liabilities of the parties on the issue based upon ultimate facts as disclosed by the pleadings and judgment. Now, admittedly, it does not say that there's a specific degree of finality. However, two things show that that is the case. One is the precise wording that has been used by the Kansas Supreme Court in multiple decisions. And two is how this court and the Kansas Supreme Court have applied that doctrine in previous cases. It's worth noting that in 1983, State v. Fisher, syllabus 4, the Kansas Supreme Court actually did institute a finality requirement. However, they have admittedly backed away from that. Syllabus 4 reads, under the rule of collateral estoppel, when an issue of ultimate fact has been once been determined by a valid and final judgment, that issue cannot again be litigated between the same parties in any future lawsuit. However, beyond syllabus 4 in State v. Fisher, the use of the word judgment certainly denotes finality. That's understood to mean a final determination of rights and liabilities of the party. And further, in Jackson Track Group, the court went further to point this out, saying that issue preclusion or collateral estoppel prevents relitigation in a different claim of issues conclusively determined in a prior action. There's certainly an indication that some degree of finality is necessary before collateral estoppel will be applied. And the 10th Circuit certainly believed that to be true in 1997. In deciding the case of Phelps v. Hamilton, the 10th Circuit, applying Kansas law, stated that the central issue, the principal question to that appeal, was whether or not the decision was sufficiently final to render those state decisions final for collateral estoppel purposes. Therefore, the 10th Circuit certainly thought that finality was not only a issue, but a principal issue in that appeal. Additionally, beyond this language used by the court on multiple occasions, the way that collateral estoppel has been applied shows that finality is a consideration. This court in 2008 noted that an arbitration award that is still subject to appeal cannot form the basis of collateral estoppel. Again, the focus of the court was upon the fact that it was subject to appeal. It might be changed and therefore lacked finality and would not be used to definitively resolve an issue in a subsequent action. Perhaps most striking, though, is the Kansas Supreme Court case of Venters v. Sellers. Sellers dealt with a underlying claim in which plaintiff's counsel and co-counsel were initially disqualified. They filed an appeal on that matter, but voluntarily dismissed the appeal when they retained new counsel. Approximately 2 years later, co-counsel, who had been disqualified under the order, arguably, re-entered his appearance. The court then found that he was still disqualified based upon what the court used a blanket term of res judicata. As the Kansas Supreme Court noted, it was very unclear whether that was supposed to be res judicata issue preclusion, claim preclusion, collateral estoppel, or even law of the case doctrine. So it undertook an analysis of all three. After laying out the three elements as they normally are in 2 sentences, the Kansas Supreme Court conducted its analysis before determining that collateral estoppel was inappropriate. Those 2 sentences are simply, these conditions are not met here. Again, there has been no prior judgments on the merits of this case. That's important for a couple of reasons in this determination. One is that it shows that dismissing or otherwise ending an appeal or a pursuit of making something more final does not necessarily end the inquiry. And 2, that the court is looking for something definite, something that cannot be changed later. It goes on to cement that when describing the law of the case doctrine. Comparing it to both collateral estoppel and res judicata, it says the key difference, most important here, is that the law of the case doctrine does not require a final judgment on the merits. Finality is very important in this case because the decision that's being used as the basis of collateral estoppel here is a preliminary order in a workers' compensation matter pursuant to section 44-534A. That section explicitly states about such an order, except as provided in this section, no such preliminary findings or preliminary awards shall be appealable by any party to the proceeding, and the same shall not be binding in a full hearing on the claim, but shall be subject to a full presentation of the facts. 3 important things can be pulled from that language. Number 1, this decision is not binding even in the workers' compensation claim. It's a preliminary decision based upon some specific need, often TTD or off work benefits, as was the case in this preliminary order. Second, there's no right to an appeal absent 4 enumerated instances, none of which apply to the appellant in this case. And 3, the statute contemplates that a full presentation of facts is going to be necessary before a final decision is made. That is not in line with a conclusive determination that the Kansas Supreme Court has repeatedly stated is necessary for an order to, or a decision to later collaterally stop a party in a subsequent action. Additionally, the fact that the claim was settled before a final hearing does not render that decision sufficiently final. Again, Venters is the best example of this. There, an appeal voluntarily dismissed, but that still did not create the finality necessary to later collaterally stop that decision whenever it arose again in the district court. Further, punishing a party for settling a claim would go against the public policy of Kansas. The purpose of the collateral estoppel doctrine and equitable doctrine is to preserve judicial resources. Far more judicial resources are preserved by amicably resolving claims than applying collateral estoppel. To say that every preliminary order places either one of the parties or both parties in danger of being collaterally estopped in a subsequent civil action would needlessly draw out workers' compensation claims to final hearings for no reason other than to avoid having to decide something in a civil lawsuit. The more practical approach is to allow those decisions to be redecided in a civil lawsuit unless the workers' compensation claim goes to a final hearing of its own volition. And that's particularly important, not so much for claimants, but for employers. Employers and workers' compensation claims are often represented by attorneys chosen by their insurer. The insurer's interest, though often aligned with the employer, is not necessarily always aligned, particularly when you're reaching outside the realm of work comp claim. An insurer may lose at a preliminary hearing, find that the claimant was not discharged for cause, and decide rather than fighting that claim to the end to see if they could get that decision reversed, they'd rather save the money and pay the claim to end it. The employer, on the other hand, if they suspect that a wrongful discharge lawsuit is coming, would be very reluctant to accept a preliminary order saying that they didn't have cause to fire this individual, and therefore collaterally stopping at least some of their arguments in a subsequent matter. They'd want to push to fight that claim to the end. That could put the employer and the insurer in quite a difficult situation. The easy resolution to that problem is to simply hold that with preliminary orders lack the finality necessary to collaterally stop in a subsequent action. Griffin v. Dodge City is not inapplicable or an opposite with what appellant is asking this court to hold. In fact, it's consistent with it. In Griffin, the matter was a final order that had already been subject to one level of appeal. And in fact, the court in Griffin seemed to think that that was important when deciding that collateral estoppel was appropriate or could be appropriate for such an order. It noted the procedural posture, including the appellate route that case had taken, and then said, therefore, this is a final judgment on the issue. Again, the court is looking for that finality, which was certainly there in Griffin, having been a decision by the ALJ and then appealed to the district court as was appropriate at the time of that decision. Additionally, Murphy v. Silver Creek Oil, again, is a final determination appealed to the director as was appropriate at that time as far as the appellate route. No case has ever held that a preliminary order is appropriate for collateral estoppel. And quite honestly, looking at Griffin and Murphy, looking for that finality, that exhaustion, it is important to the courts, or appeared to be important to the courts. They certainly undertook that analysis when discussing collateral estoppel. Appellate's not arguing that those cases are wrongly decided, that they need to be overruled or quite honestly impacted at all. A preliminary order is simply not a final order, and therefore it has a different outcome. But regardless of the finality and whether collateral estoppel is appropriate for preliminary orders in some instances, here the issue was specifically reserved for resolution in this later matter. It's well settled that collateral estoppel will not apply to issues that are directed to be litigated in another forum or another action. Looking at 3 Kansas Supreme Court cases, it's clear that bar is relatively low. In Jackson, it was a narrower issue of damages that was decided in the subsequent thing, and it was its subsequent action, and it was specifically reserved by the plaintiff in the original action. That was held sufficient. In Meenan v. Meenan, it was sufficient to simply state that the judgment can serve the rights of the parties. That avoided collateral estoppel. That arguably quite vague statement by itself did the trick. And in Gillette v. Powell, a final judgment was issued. Then later, the final judgment was amended to simply remove reference to any mineral rights. It did not state anything affirmatively about leaving that issue open, but that was held to be sufficient to prevent collateral estoppel from being applied in a subsequent action. Together with these, it shows this is a relatively low bar. And at the settlement hearing, appellant's counsel, and this is from the record at I-101-102, stated, the only thing is there's also a civil lawsuit that is going on, and the civil suit didn't occur until a month later or so. So I just want to make sure that everybody understands that, well, not only does the judge, the work comp judge, not have jurisdiction over the civil suit, that in no way, shape, or form are we giving up any rights for the civil suit that is currently pending. The ALJ replied, all right, well, I have no jurisdiction over those matters, only workers' comp, so I'm out on that one. Jackson, respondent's counsel, any questions you have? No questions, Judge. This is just resolving the workers' compensation case. Based on Jackson Group, Meenan, and Gillett, that is sufficient to reserve an issue for later resolution. It meets the low bar that is required. I will return to speaking to the court again with rebuttal. Thank you.
Well, counsel, let me ask one question. Let's go back to the preliminary order in the workers' compensation case. And I haven't reviewed the record well at all, but does our record reflect what evidence was presented to the administrative law judge at that preliminary hearing in the first place?
It does, Your Honor. There was testimony from the claimant herself, testimony from a supervisor, and I believe there may have been testimony from one other individual, as well as some documents from her personnel file.
All right, thank you. Mr. Burkholder, I guess we switch over to you whenever.
All right, thank you. Thank you, Your Honor. May it please the court, Vaughn Burkholder appearing on behalf of the defendant appellee, KVC. Your Honor, the three-part test under Kansas law for application of collateral estoppel requires three elements. One, a prior judgment on the merits on the same issue. Two, between the same parties or parties in privity. And three, that judgment was necessary to support that prior judgment, or rather that those issues were addressed in that prior judgment. All of those elements are present in this case, and the appellant doesn't argue that those elements are not present. They simply question, well, what we have here is, yes, it's a prior judgment, but is it final enough? There is no obligation or no requirement under Kansas law with regard to collateral estoppel that makes the requirement for a prior judgment a final judgment. So Ms. Miller is trying to escape the application of collateral estoppel in a couple of different ways. She first argues that the administrative law judge's decision, even though it meets the Kansas test by being a prior judgment, isn't final enough. And second, by arguing that the issue of whether KVC terminated Ms. Miller for a legitimate reason or not was reserved by the parties at the settlement hearing, which concluded the work comp case against KVC. And let me address their second argument first. It was last addressed by counsel. Counsel states that there's a low bar for establishing that an issue was reserved after once decided. Well, the bar may be low, but the bar does exist. There's no evidence to support in this case that at the settlement hearing conducted by the special ALJ, who is different than the judge who entered the prior judgment, that the issue of why Ms. Miller was terminated was being vacated or reserved for relitigation in a subsequent civil case. All of the cases cited by counsel for Ms. Miller have some indication in the record in the case that either the court was specifically reserving issues for later determination, or that the parties had reached an agreement that the issue that had already been decided was going to be set aside and determined in a later proceeding. Neither of those things occurred in this case. What happened was counsel for Ms. Miller made a statement that all we're doing is resolving the work comp case here today. We're not intending to affect the civil case. And the special ALJ simply said, my jurisdiction is limited to the workers' compensation case. And I think he said, so I'm out on that one. And then there was no statement by counsel for KVC, who was different at that time, to the effect that, yes, we're reserving any issues in the civil case that's currently pending. So although it's a low bar, you still have to be able to find that either the court or the parties reserve the right for later determination, and that does not exist in this case in the either the preliminary hearing, or rather the settlement hearing order, or in the settlement hearing transcript. Now, Ms. Miller's other argument has to do with the nature of the hearing, following which the order was entered, finding that Ms. Miller was, quote, legitimately terminated for cause. That was the language used by administrative law Judge Hirsch in this case. And if that finding stands, that she was legitimately terminated for cause, then that does away with the claim that Ms. Miller has filed in the civil lawsuit, stating that KVC retaliatorily terminated her for pursuing the workers' compensation case, which obviously would not be a legitimate termination for cause. Now, as counsel just pointed out, as we know from the preliminary hearing order that was entered, we don't have the transcript of that hearing as part of the record, but we do know that Ms. Miller herself testified at the hearing. She introduced documentary evidence, and there was a witness on behalf of KVC that Ms. Miller's counsel cross-examined. So all of that occurred at the preliminary hearing in front of Judge Hirsch. All of it concerned the circumstances of her termination from employment at KVC, because of the, excuse me, that was the issue at that hearing. Now, Ms. Miller argues that the order issued by the ALJ following that hearing wasn't a final order because it could have been the subject of modification by the ALJ in additional proceedings. But the fact of the matter is, in this case, that order was never modified because Ms. Miller knowingly gave up the right to have that order reconsidered in a subsequent hearing. And she instead settled her workers' compensation claim. And by settling the claim, not agreeing with counsel for KVC that order was vacated, or not getting a judge in the work comp case to order that prior order was vacated, that order remains intact. Now, Your Honor, I'd like to point out that in the part of the statute that counsel referred to where it talks about the hearing being summary in nature, and I'm referring specifically to KSA 44534A, small, or rather 2 in parentheses, it goes on to say, quote, "The administrative law judge shall exercise such powers as are provided for the conduct of full hearings on claims under the Workers' Compensation Act," close quotes, and that's specifically referring to the preliminary hearing. The only reason it's called a preliminary hearing is because there are some issues, such as temporary total disability benefits, which were issued in this case, or in other cases, medical compensation, that need a quick determination, but not necessarily a substandard determination. There's no indication in the record that Ms. Miller attempted to introduce any additional or would have introduced any additional testimony, but the judge stopped her from doing so, or the court ever ruled that there was evidence that could have been considered, which he did not consider. So what this means is that although it's called a preliminary hearing and it's subject to a later determination, there's nothing in the Workers' Compensation Act that says that that's a second-class order or somehow an order which is not as good as a subsequent order, which could possibly decide the issue differently. But again, the fact of the matter in this case is that the preliminary hearing order, which conclusively determined that according to the judge, based on all the evidence heard at that hearing, that she was legitimately terminated for cause, that is a final order because it was never subject to any subsequent order. Now, if Ms. Miller had not chosen to settle her work comp claim, but had instead gone on to a later hearing and was able to convince the administrative law judge to reverse his previous order and to find that she wasn't terminated for good cause, then we, KVC, would not be in a position to argue that that October 2019 order precluded her from bringing this claim, because that prior order would necessarily have been vacated by operation of the later award of compensation where the judge changed his mind. But that's not what happened in this case. Instead, Ms. Miller gave up her right under the Work Comp Act to try and convince the ALJ that his earlier order had been incorrect. So that earlier order, which, to use the language of collateral estoppel in Kansas, was a prior judgment on the merits that determined the party's rights and liabilities on that issue, that became a final judgment in that proceeding, because there never was a subsequent hearing because Ms. Miller gave up the right to have that subsequent hearing. And the interesting thing is that this procedural provision of the Kansas Workers' Compensation Act, which allows the administrative law judge to reconsider his or her first decision on an issue, this was Ms. Miller's opportunity for a second bite at the apple to prove what she couldn't prove the first time. It's a baked-in second chance in the Workers' Compensation Act. It's a specific feature of that act, and it's the only time that this litigant, Ms. Miller, should be given a second shot at proving something she could not prove the first time. And this is the heart of our argument in response to the appeal here. By not litigating her claim to a final award after the October 2019 preliminary hearing order was entered, Ms. Miller waived the one opportunity the law gives her to litigate the same issue against the same party again. She waived that opportunity by choosing to settle her workers' compensation case. And now she wants this court to contort the law of collateral estoppel to allow her yet another chance, in effect, a third opportunity to prove her claim when she couldn't the first time she was given an opportunity to do so, and when she waived the second opportunity that was her right under the law. Your Honors, this is essentially the same situation with which this court was presented in, well, 25 years ago in the 1996 case of Griffin versus Dodge City. Really, the only difference between this case and that case is the Griffin case settled a little further into the work comp claim process than this case did. In Griffin, there was an issue regarding the plaintiff's ability to return to work. It was litigated in the workers' compensation claim, and it was settled while the claim was still being litigated. Now, in the Griffin case, the court found that collateral estoppel applied, even though the case was currently on appeal at the time that Mr. Griffin settled his case. He had gotten what is called a final award. He had appealed it to the district court and appealed it to the Court of Appeals, but nevertheless, at the time that the subsequent court said collateral estoppel would apply, Mr. Griffin still had that decision from the lower courts on appeal in the Court of Appeals. So the fact that the decision of the
Counsel, we have a question, please.
Yes, I'm sorry.
Counsel, isn't that the main difference between Griffin and this case? In Griffin, you had an ALJ award that was appealed to the district court, and you had a judgment from the district court, and that's actually what was on appeal in Griffin at the time, that we're claiming there's a preclusive effect. But here we only have a preliminary order. We don't have a final award, nor do we have a judgment from the district court. We have a preliminary order, which by statute is described as not binding and still subject to a full presentation of the facts. I guess just to be clear, that's what I'm struggling with. Is to me, Griffin seems very different than the situation we have here.
And Your Honor, we would submit that that is a factual difference without any legal distinction, because the preliminary award is only preliminary unless and until there is a final award entered. But if there is never a final award entered, or say contested at all, and the parties don't fight that, it becomes a final award. Now, final is not a requirement of collateral estoppel, only a prior judgment. And we have a prior judgment. And the courts have said that a prior administrative decision can have the same effect as a judicial decision by a district court. The fact that it occurred, the decision was made by an administrative law judge in an administrative forum does not mean that it is not entitled to be considered a judgment when it comes to considering collateral estoppel in a later civil action. There are several cases which stand for that proposition. So it's a semantic distinction to say, well, what we're talking about in Griffin is a judgment from a district court as opposed to an order from an administrative law judge. The courts do not recognize any distinction, or the case law does not recognize any distinction between the administrative order and the district court decision. But the point is where you say, well, it's a preliminary hearing because it's pending a final decision or it's subject to a final decision. That's all good and well if there is ever a final decision. And as I said, if there had been a final decision from the administrative law judge that was different than the preliminary hearing order, which is an order, which is a judgment, then we wouldn't be in this position. But that's not what happened. Ms. Miller waived her right at a second bite at the apple and to try to prove that something happened which she wasn't able to prove the first time. So I think if the court will look at the statute, you will determine that it's only not a final decision at a preliminary hearing order until there is a final decision. So just like in Griffin, both cases were on appeal at the time the case was settled, and yet a later court said, sorry, Mr. Claimant in the workers' compensation case, now as a plaintiff in a civil case, you cannot relitigate against the same party, the same issue that was previously decided and the result and the subject of a prior order, not a final order, but a prior order. I hope that addresses the court's question. Did you have a follow-up?
I do. Based on the last comment that you made, I mean, it's my understanding at the preliminary hearing, you're looking at, and I believe your phrasing was she legitimately terminated for cause? And we're looking at KSA 44-510C B2C, right? That's the question at the preliminary hearing, is that whether you're terminated for cause?
That's correct, Your Honor.
And in the civil case, we've got a retaliatory discharge claim, which answers some different questions. I mean, in a civil case, for example, if you're looking at a retaliatory discharge claim, we've got nuances that would be considered. For example, the retaliation doesn't have to be the only reason that you're terminated in order to have a triable claim. Or sometimes we have a complex burden of proof shifting, and you look at pretext and you look at whether the employer's reason for termination was pretextual. I mean, do any of those civil considerations with respect to a retaliatory discharge claim come into play in a preliminary initial determination under the statute in a workers' compensation case?
Yes, Your Honor. The ultimate issue is the same. Was Ms. Miller legitimately terminated for cause or not? If a court, whether it's an ALJ or a district court, or whatever appropriate tribunal finds that someone was legitimately terminated for cause, that is mutually exclusive with a determination that the person, was retaliatorily terminated and not for cause. So you cannot have both of those things existing at the same time. If you're terminated for cause legitimately, you cannot have been at the same time illegitimately terminated, not for cause, but in retaliation, in this case, for bringing a workers' compensation claim. So although there might be some nuances that are different, the ultimate determination is exactly the same in this case. The issue for presentation and decision by the tribunal, whether it's administrative or judicial in nature, is whether or not the termination was legitimate or not. And if it was legitimate, it cannot also be illegitimate and retaliatory.
So under your position, a claimant could never settle their workers' compensation case if they wanted to pursue a civil retaliatory discharge claim then?
They could settle their case if they got the court to definitively order that its decision had been set aside as part of the settlement, or if the parties specifically entered into an agreement, which is clear upon the record. It doesn't have to be long. It doesn't have to be a lot, as counsel points out, but it has to be clear that either the court or counsel agreed that the decision made in the workers' compensation case was not binding on the later case. All we have in this case is the administrative law judge who heard the settlement hearing saying, I can't make any determinations in that regard. And we have Mr. Doyle on behalf of Ms. Miller stating unilaterally that he doesn't want what happens in the work comp case to affect the civil case, but there was no consent by defense counsel saying, yes, that's right. We agree that the prior determination by the judge in this case will not allow or will not affect the civil case. Again, we really do have the same situation as Griffin. I think it's a factual distinction without any legal difference as to where in the process the determination comes from the lower court for which collateral estoppel is going to apply in a later civil proceeding. And I'm sure I've used up all of my time. Thank you, Your Honors.
Yeah.
All right, thank you, counsel. And Mr. Bruce, you still have your rebuttal time.
Thank you, Judge. I have two brief points on rebuttal and one minor clarification. I would just note in Griffin, the decision that was used to collaterally stop was the decision of the district court. It was not appealed by the claimant. It was appealed by the employer and voluntarily dismissed and settled by the employer on April 20th, 1994. The lawsuit in Griffin was filed about a month later, May 23rd, 1994. It was not on appeal at the time that collateral estoppel was applied. council stated that a preliminary order is not a second-class order and it can be final. That's simply not the case looking at this statute. First, as we've said repeatedly, the last line of section A2 is that it will be subject to a full presentation of the facts. That inherently indicates that at least the legislature was not confident that a full presentation of the facts was going to be available in a preliminary hearing. Further, a preliminary hearing, reading the statute, can never be subject to judicial review. In 4 instances, it may go to the board, but it will never go to a court. It will never go to the Court of Appeals. It will never go to the Kansas Supreme Court. It states so right in the statute. Such review by the board shall not be subject to judicial review. I think that makes a huge difference as far as whether or not an administrative decision is appropriate for collateral estoppel. You have this administrative body that's making a decision that can never be touched by a court, unlike a final order, which can and often is. In fact, the previous case is an example of that. Preliminary order is out of the reach of judicial review, and I think that's a huge distinction, especially when we're talking about collaterally estopping claims, civil claims in other regards. Additionally, the argument that if it's not reconsidered, it must be final is disproven by Venters. In Venters, that decision was initially appealed. It could have been reviewed and it was abandoned, and that still did not create enough finality to collaterally estop it later. The fact that it could be subject to review is a consideration. It certainly is, and this court has noted in appropriate circumstances that may constitute enough finality to apply collateral estoppel, but it is not definite. And in this case, what we have is an order that was not binding in the decision, in the claim that it was made. It was not subject to a full conclusive determination of facts based upon the language of that statute, and it was not subject to appeal by any tribunal, let alone a court, and it can never be subject to an appeal by a court. Holding that any claimant or any employer who's litigating the issue of TTD, which necessarily includes a termination, is going to have to take that to its finality, creates a huge disincentive and a huge problem for resolving work comp claims, which are supposed to be quicker, faster, and easier than civil lawsuits for personal injuries. Therefore, the court's entry of judgment on the pleadings in this matter should be reversed, and this matter should be remanded for further proceedings. Your Honors, I thank you for your time.
Anything else? All right, counsel, thank you very much for your briefs and your arguments. As I said earlier, your case is now deemed submitted for decision, and we will get a written decision out to you and your clients just as soon as we possibly can. And with that, this hearing is